Chairman, I knew that. And I'm going to moderate this forum between the two candidates for the open seat on the Georgia Court of Appeals. If you can't hear me, let me know. I'm probably not going to lean into this mic. You can't hear me? Okay. So I'm Kyle Wallace. I'm an attorney in Atlanta. I do a lot of appellate work. And I'm going to moderate tonight's forum between the two candidates for the Georgia Court of Appeals. This will be the first time these two candidates have participated in a joint forum together. We're going to go through opening statements and have some questions and answers. We'll take questions from you guys. Obviously, this is a unique race in the sense it's nonpartisan. They both graciously agreed to be here tonight and take your questions, but they will be subject to both these guys are subject to the Code of Judicial Ethics. And so we have to be careful not to ask questions that will cause them to state a position on a case that may come before them should they be elected. There's an open seat on the Georgia Court of Appeals because a member of that court is running for the Georgia Supreme Court and will end his term at the end of the year, creating this open seat. That gentleman's name is John Ellington, and both of these fellows are running for his seat. And the Georgia Court of Appeals is the state court of intermediate review. So we have a Georgia Supreme Court, and right below it we have a Georgia Court of Appeals. Most of the decisions made in the courthouse next door, if appealed, would go to the Georgia Court of Appeals. There's a few cases that do not, but most all of them do. So I just gave you that high-level overview just for your benefit if you didn't know that. But to my left is Mr. Ken Shigley, an attorney in Atlanta, and he can tell you more about himself. And to my right is Mr. Ken Hodges, an attorney from South Georgia, but I do believe he's now in Atlanta. Is that correct?
Practicing both Albany and Atlanta.
Okay. And so right now we're going to do opening statements, and alphabetically I'm going to allow Mr. Hodges to go first.
Good evening. It's good to be here in Cherokee County with y'all. As Kyle said, my name is Ken Hodges, and I'm running for the Georgia Court of Appeals. I went to school in Atlanta, Emory University, and then went to the University of Georgia School of Law. After doing that, I practiced law in Atlanta for a short period of time before returning to my hometown of Albany, and I was an assistant DA for a few years until I went back into my father's practiced for a couple more years, and then decided to run for the office of district attorney. I ran for the office of district attorney because, quite candidly, we had a really bad one, unlike y'all have here with Ms. Wallace. The one we had let folks sit in jail 3, 4, 5, in one case 7.5 years without going to trial. And child molesters were getting off half the time they went to court. And I didn't think that was acceptable. And actually, in one of the death penalty cases that was pending, the death penalty defendant got out on bond because he wasn't indicted on time. And that was actually the straw that broke the camel's back with me. I was born and raised there. I had worked in that office, and I knew how bad it was, and I knew it needed to change. My dad had built a very prosperous insurance defense firm and wanted me to stay there and work with him. But I decided that was my calling in 1996, and so at the age of 29, I offered to run for the office of district attorney and was elected. And quickly, I worked to reorganize that office. I made sure that people were indicted on time so they didn't get bond because they weren't indicted in a timely manner. I made sure that office ran at or under budget every single year. And I also prosecuted and sought the death penalty when it was appropriate and was personally involved in more than a dozen death penalty cases, trying several of them myself. And I obtained the first death penalty in Dougherty County in more than 50 years when the first case got tried. One of the main things that I'm the most proud of as district attorney, because I'll tell you, when I ran for one term and one term only. I wanted to get in there and turn it around and leave. But it took a lot more time than that, and there to stay in 12 years. The main thing that I wanted to change was that conviction rate on child molesters. People would prey on the most innocent. And at that point, it was the flip of a coin whether somebody went to prison or not. So I worked to establish an advocacy center for children and women. It grew out of my office. It started only in Dougherty County when I started it. And it now serves 32 counties in southwest Georgia. It's called the Lily Pad SANE Center. SANE stands for Sexual Assault Nurse Examiner's Program. And it has increased the conviction rate on crimes against children from below 50 to near 100%. And so I'm delighted about that. Especially because I live in Albany. And I've got a young girl who turns 9 next month. and a young boy who is 7 years old, and that's where my wife and I live. I also, as Kyle mentioned, practice law in Atlanta, so I'm back and forth. I enjoy in my spare time hunting and fishing. I grew up hunting out in the woods. I grew up on a dirt road in Lee County, Georgia, and I took my little boy hunting for the first time last month, and it was a wonderful experience. I kicked off this campaign about a year ago, and my campaign chairman is Saxby Chambliss, who was the former senior senator of the state of Georgia. And he is working with me, along with many others, to get the message out all over the state, because I doubt that I have met many of you in this room. I'm looking out, and it's hard to see in the dark in the back, but I grew up on the other side of the state. And so we've got to get the message out all over the state, but I'm happy to be here with you tonight. Something else I'm happy to announce is this morning we put out that Senior Senator Johnny Isaacson is supporting my campaign. And I've got a number of other very conservative leaders like Jack Kingston and Bob Harr, both former congressmen, supporting the campaign. And I say that to say, as I said, you may not know me, you may not have interacted with me because I live on the other end of the state, but birds of a feather flock together. And I've got the same conservative values that I'm certain that most of you have in this room. My career is the most balanced. Half of my career was spent, more than half of my career was spent as a prosecutor, and the other half was spent doing civil work on both sides of the V. In other words, if you've been sued, I would represent you, or if you have a lawsuit with Barrett, I would represent you as well. I've got 30 seconds left, so I'll just wind up and tell you I hope to answer your questions tonight. If we don't get to a question that you want answered, I'll stick around and would love to meet with you and talk to you. I need your vote. I need your support. Thank you for being interested tonight. There are not a lot of interested voters anymore, so I appreciate that there's no apathy in this room, and I hope that we can get your questions answered.
Thank you, Mr. Hodges. Mr. Shigley, would you give an opening?
Thank you. I'm Ken Shigley. It's my third time with this group in the past 6 or 8 months. I'm glad to be back in Cherokee County. Back when I was working with my son's Boy Scout troop, we taught the boys when they broke camp to line up fingertip to fingertip and go across the campsite picking up the debris that somebody else left years and years ago, and to leave the campsite a little cleaner than they found it. And if I have the privilege of serving on the Court of Appeals, that's what I would like to do with some of the Georgia case law. Those of you who are lawyers and who practice in our courts know that we have case law cases that may not follow the Constitution and its original intent, may not follow the language of the statutes that have been enacted, and may not agree with each other. And when those inconsistencies occur, there's a process you have to go through to clean it up and leave it a little cleaner than you found it. We can go into examples if y'all want to, but one example of a case that came out from Judge Nellis Peterson, who grew up in Cobb County and went to Kennesaw State before he went to Harvard Law School, and he was on the Court of Appeals before he went to the Supreme Court, had a case that dealt with the interpretation of the statute of limitations. And there were cases all over the place. And he goes back and says, okay, what does this statute say? What does it mean? There are cases over here that don't go with the statute. We need to disapprove some of those and go with those that do and clarify the law. So one thing I want to do if I'm elected is to help to bring greater clarity and consistency to Georgia case law to help guide the courts, lawyers, and the parties, the clients, in their own transactions. Now, what about my background matters? Well, first, I mentioned I completed a term 6 years ago as president of the State Bar of Georgia. That includes all the lawyers and judges in the state. If you take it seriously, it's an exhausting full-time volunteer position for really more than the year that you're actually president, if you take it as seriously as anyone should. Now, as your Superior Court Clerk, Patty Baker, knows, I've worked really, really hard on court technology that year. She can tell you what we went through together. Governor Deal appointed me to the Criminal Justice Reform Council, trying to protect public safety while at the same time watching out for the public purse and what's spent on prisons. the Judicial Nominating Commission, at the end of that time in 2012, nominated me on the short list for appointment to this court, the Court of Appeals. And it looks until the end of that year that I might get it, and then political winds will go a different direction. That's fine. I told Governor Deal a couple of weeks ago they probably did me a favor by not appointing me that year because let me get back to my practice and making money, taking care of my family. A second thing is, Court of Appeals judges deal with paper, with briefs, with law, with reading and writing. I wrote a book that has been cited as an authority by the Georgia Supreme Court a few times. If anybody ever asks you to write a book that requires annual updates with footnotes and legal citations, tell them it's not worth it. But it is relevant to the job that a Court of Appeals judge does. Now, I also have 40 years of legal experience that is varied. I started out as an assistant district attorney in my hometown. The first trial that I actually participated in, assisting the DA, was a death penalty trial for vicious rape and murder. I did prosecute child molesters and sent them to prison. I sent burglars and rapists to prison. I could go on and on. Now, I did not have the opportunity to move up and become DA. The politics of the hometown were such that it was not going to be an opportunity for me. I moved on to hometown general practice, doing whatever came in the door for a few years. Then I did go to what was an insurance defense firm, defended cases for insurance companies, for state and local governments all over the state. And then wanted to take better care of my family than I could in the economic model of that firm. I started my own firm for the last 27 years. I've been representing ordinary people, and I raised my family on that, making payroll and running a small business. Now, I'm running with no personal or political agenda. I have no further aspirations. I have not lined up a bunch of career politician endorsements because I am not a career politician. I did not run as a Democratic nominee for Attorney General in 2010, as my opponent did. I'm running to provide greater clarity, consistency, and predictability in Georgia case law according to our traditional values. Thank you.
Thank you, Mr. Shigley. And as you see, we ran up against the time there. If we get close and we're 10 seconds over, we're not gonna drop the gavel. We'll let them finish their thought. You mentioned this question is going to go to Mr. Shigley. I'm going to try to rotate as best I can as to who goes first. Just a heads up on that. You mentioned a minute ago the lack of clarity in the law, and as a lawyer, I think every lawyer in this room has probably heard the saying that if you hadn't found a case in the Georgia Court of Appeals that supports the position that you're taking, you haven't looked hard enough. And that is kind of a running thing that people say. You mentioned a minute ago that you wanted to reconcile the law. Recognizing that the Georgia Court of Appeals is one of the busiest intermediate appellate courts in the country, can you give me your thoughts on why do you think it is that there's so many inconsistencies among the opinions? Is it because they publish too many cases? What do you think you can do to make a difference as to that specifically?
Well, as one judge of 15, my first approach would be to actually read all the briefs of authorities of the cases assigned to me and look for those areas of inconsistency. One judge down there, who I will not name, told me in a parking lot at a country club after a couple of drinks, they never looked at a case until a staff attorney wrote the proposed order. And then when you don't have formal conferencing among the panels about their cases and talk about them, there's a very slippery slope between that and a one law court decision. So at this point, my kids are grown, my wife passed. I don't have anything to do with read turgid lawyer briefs, you know. So the first thing is to actually read those briefs and the authorities they cite and ferret out the areas of inconsistency. And as one judge of 15 worked on trying to clarify.
Thank you, Mr. Shigley. Mr. Hodges, same question.
Well, certainly, I think we need to have consistency in our legal opinions. I think first and foremost, judges who are elected need to understand their role, and they are not legislators. We have three forms of government, or three branches of government: the executive branch, the legislative branch, and the judicial branch. And the legislative branch is where the laws are passed, and it's up to the court to enforce those laws, not to legislate from the bench. I agree with you that there are inconsistent opinions at the Georgia Court of Appeals, and we need to work together to clarify that, because if you're the owner of your business, and I'm the owner of my business right now, and I represent many owners of many businesses in their endeavors, and you're trying to make strategic long-term business decisions, you can't make decisions if there's not clarity in the law. And so I believe that it is incumbent upon the court, and I believe it is their duty to make sure that they have consistent opinions. And what we need to do is, when we see that we have the state, or Jones versus Smith over here, and Adams versus Rice over here, and the outcomes are inconsistent with each other, with the next court case that is on that issue, we need to either overrule or harmonize the opinion that needs to be changed to provide clarity. And we need to provide clarity and a clear roadmap so that people can understand what the law is.
Thank you. So just following up on that, there's a rule in the Georgia Court of Appeals that allows a judge on a panel. They sit on panels of three. I'm going to ask you this question because we're rotating, so you're going to go two at a time and swap around. But there's a rule that allows a judge to concur in the judgment only, which means that they're not agreeing with all the words in the written decision, but they're not disagreeing with the result. In doing so, they make that case to where it's not precedential in other cases. Is that overused, in your opinion, by the Court of Appeals? Or would you hesitate to concur in the judgment only versus now you can write a dissent without it automatically triggering a en banc review process?
Well, I think that, the reason for opinions to be published and to be out there, it really doesn't, why are you going to do that if it doesn't have precedential value? And I'm also concerned that currently you have one judge deciding it, even though there's a three-judge panel. There's not, the great thing about having three judges look at a case is you can get difference of perspectives. One of the perspectives that I will bring to the court that is not deep now is a deep base of having been actually in the courtroom litigating cases on all sides. And so I will bring that. And when that's important to the case at hand, I would hope that the other two would accept that information in their analysis, and we could have a dialogue about what is the best outcome and actually come up with the best decision, because I think the collaborative approach is the right approach. Otherwise, why not just have an appeal court of one? So we need to have that discussion and dialogue and come up with the right opinions. But yes, I think if you're going to go to the trouble of having an opinion that's going to be published, and out there, taking away its precedential value seems counterproductive and undermines the process.
Thoughts on that?
Well, I think that the recent rule change to allow a dissent without kicking over to full panel, I think is probably valuable in that if you have another view, you can write it without making it non-presidential or kicking it over to panel 15. I think one thing we agree on is the current court has a lot of people who are very bright, and I like them all, but they didn't spend a lot of time out in the trenches. And I've been in the trenches for 40 years. Last time I was in this room, I was trying a case, and there was a gentleman over there in the corner on the second row of the jury box, where the jury box was back then, who kept falling asleep. I'm glad y'all are staying awake for us, even though it's evening. So I've spent a lot of time in the trenches, and I think you take some wisdom and some discernment to the court from having seen a lot of stuff in both civil and criminal cases over a career. And you bring something to it that somebody who clerked for a federal judge, spent 3 years in a 700-member firm, no offense, and then work for a politician and got appointed to court. I think we do bring something to it from experience down in the trenches. If I get there, I'll probably be the only one that ever tried a dog custody case in justice of the peace.
Well, what role do you think your personal views and political ideology should play in deciding appellate cases?
Very little. I would, as he said, we agree. Judges are there to follow the law. They're not legislators. They're not there to impose their policy preferences. Justice Scalia was a great proponent of an approach called textualism for determining the original intent of a constitutional provision or a statute. If you go to my website, kenshigley.org, you'll see some things I've written, including an article, Ladies and Gentlemen of the Constitution of the United States. The most reliable methodology, I think, for trying to discern the intent of a constitutional provision or of a statute is to look at the public meaning of those words and phrases as they were used at the time they were enacted. Now, there's a lot of hubris or sinful pride in thinking that that's going to determine the outcome all the time, because people who are determined to manipulate an outcome will do it anyway. But one judge who I like very much, Steve Dillard, who's currently the Chief Judge of the Court of Appeals, used the term death to self. Put aside your own policy preferences to the greatest extent you can and look at what the statute or constitutional provision means and how do you honestly apply that to the facts and the law and the situation in front of you.
Yeah. Do you have the same view on personal views and how they should play a role in decision making?
No, and that's where we differ. Mr. Shigley said that his personal views or beliefs should have very little impact. I think it should have none. I told you before, there are three branches of government: the judicial, the executive, and the legislative. I thought that my personal views were impactful of how to interpret the laws. I run for the legislature. I'm running for the court, and my job is to enforce the laws that the legislature enacts. And I think that has to be a very strict line, not no leeway at all in that.
So if you're deciding a case and you're writing an opinion and you don't necessarily agree with the result and you think that it's perhaps absurd, but you're reading the statute on its face, do you do anything beyond just write the opinion, or are you of the mindset that you try to, it would be okay and appropriate for you to spend some time in the opinion, encouraging the legislature to maybe take action?
Oh, absolutely. And I've read that in plenty of opinions, and I would absolutely speak my mind on it. And I would say, I have to do it this way because this is the law that the legislature enacted. I think that the result is a bad result. I think there are a lot of times that there are unintended consequences of what the legislature passes, but they have been voted on by the people to make laws. And I have to interpret and enforce those laws. And I will say that I think that they should reconsider this the next time they convene, but I will not legislate from the bench.
You have the same view?
First, I think you may have misunderstood something I said about the textualism approach. The judge's personal views should not have an impact on the ruling. I think it does sneak in if you look at judicial behavior. My goal would be to simply follow the law and do what the statute or constitutional provision says according to what that language is to the educated public at the time it was enacted, and to try to guard against letting personal views become part of it. Now, as far as judicial comments on what the legislature did, if you've observed the legislature very much for very long, you know that a lot of times these guys don't really necessarily know what they're voting on. Sometimes I've seen situations where they have to vote on before they know what they voted on. But that is their job. And the judge's job is to apply that law and interpret according to what they passed. And then you can certainly comment that maybe the legislature needs to take another look at this. And we see a lot of cases where judges say that. One time I was lobbying for something as a bar bill to fix something that was a Court of Appeals decision, Judge Marion Pope here in Cherokee County. was at this committee where we were trying to get the bar endorsement for some, just fixing a technical thing. He said, "Who wrote that term fill decision? Was it me?" I said, "No, it wasn't. It was somebody else." But certainly the judges can reflect upon the unintended consequences of those issues and put some information in there. Perhaps legislators will consider or not.
You can't hear back there.
Oh, okay. Okay. What did you not hear? I think certainly judges can comment about the unintended consequences of legislation, and legislature can consider that or not.
So I'm going to ask a fun one. I'll start with you.
Good.
Identify a current or former state or federal appellate judge. It could be in the Supreme Court, except for Scalia, because you already mentioned him.
Okay.
Living or dead, who you admire and why?
Appellate?
Appellate.
Okay.
Can't be Judge Tony Baker. He's in the room.
No, go on. I was going to name him. Well, I think that I think Justice Namias on the Georgia Supreme Court is a lot smarter than public review and so forth. It has been extremely conscientious and thorough about picking apart legal issues and explaining them according to these principles I talked about. I would think it's hard to narrow it down.
Well, just anyone. It doesn't have to be your only one. How about you?
Well, you didn't put the same constraints on me, so I will pick Justice Scalia for several reasons. Number one, I've had the honor of actually going out hunting with him on 3 separate occasions. He is an avid hunter, and another good friend of mine, Judge Ed Johnson, who was on the Georgia Court of Appeals, who's my treasurer, was the connection that got us together. He came down to South Georgia 3 times, and one night we actually spent separate. All of the older guys went to bed. Justice Scalia and I stayed up talking for many hours about life in general, not one thing about the law. But he was a great Catholic father. He had, I think, 8 children. He had plenty of good stories. He was always talking about family, and that's important to me as well. And I enjoyed my 3 outings with him. And I actually went up to Washington and went to see him in his chambers. And I didn't think that he would remember or allow me in the chambers. But I went to the Supreme Court and I said, "I'd like to see Justice Scalia." Told him who I was. He invited me back to chambers. We had a great conversation.
So the jurisdiction of the Court of Appeals is vast. It covers cases from civil to criminal and almost across the entire spectrum. Can you identify, I'm going to start with you, Mr. Hodges, 3 areas that you feel like you lack substantial experience in, and explain your plan for preparing to handle those types of cases?
Well, I am, I guess, fortunate in that I am a general practice litigator. I certainly have vast experience as a prosecutor in criminal law on both sides. But I've never done specific things like tax or, thankfully, divorce, or what else, probate matters. So, I mean, those are 3 that come off the top of my head that I've never really had experience with. But what I would do with anything that I haven't had experience with before I had my first experience with it is I would seek counsel from those that have. I could certainly look to people, look to books, treatises, and other things, and become educated about it. And I would certainly become educated. I would try to become as educated as I can on every area that is before me when it is before me.
Okay, I'm going to ask you a follow-up, and I'm going to ask you both those questions because I don't want to lose the thought. So it would be common for an appellate judge to go down the hall then and maybe bounce ideas off of their colleagues when they first come on the bench and they're learning areas of law, including even some of the younger ones that may have worked in politics. I'm kidding, I'm joking. I didn't work in politics. I'm just
I was just giving you
would that be something that you feel like you would be well suited to do, to kind of build some relationships with the members of the court? Would you be humble enough to seek their counsel on some of the cases that you may not be that familiar with?
Absolutely. I think you need to do that for a number of reasons, including the reason for which you asked, to gain knowledge that you don't have. I had a rule when I was district attorney of all of my staff that there's no question that's too dumb to ask, and you need to be able to do it because you don't want to be making decisions on lack of information. And so I would absolutely go to any of the, first of all, I would hope to establish good working relationships with the other 14 immediately. And I know all of them and have a good relationship with them now, and I see there's no reason for that not to continue. But I would certainly ask them. I would feel comfortable calling my good friend Ed Johnson, who I referenced before, who was Chief Judge on the Court of Appeals, or Herb Phipps, who lives in Albany, and we frequently still get together and ask some of those people. When I was first elected, I think I told you I was 29 when I ran, I was 30 when I took office, and I sought out and had 3 very experienced DAs in the state that I called very routinely about things. And I would never hesitate to seek out information that I thought would be valuable in me making a decision, verifying the decision that I had made, or helping educate me more. That was never a problem.
Thank you. I know that you've covered a lot of areas of the law in your career, but are there certain areas, can you identify certain areas where you haven't handled?
Sure.
That you believe that you would need to bone up on, and how you would do that, and whether that would involve, whether an important part of that would be your relationships with your colleagues on the bench?
Yes. First, let me comment on the Justice Scalia hunting trip. Back in February 2012, I was in New Orleans at the World War II Museum where Justice Scalia was speaking. And Buck Ruffin, who was going to be State Bar President 2 years after me, wanted to do a constitutional symposium. And we talked about wanting to get Justice Scalia and maybe another justice to come to Georgia. And we buttonholed Justice Scalia after he spoke at the World War II Museum in New Orleans with the idea of coming to speak in Georgia. And he said, I really like bird hunting in Georgia, and that's where the bird hunting trip with Justice Scalia originated. And unfortunately, I was not able to be on that hunting trip. With regard to your question, I did some family law back in my misspent youth. I handled a lot of trailer park divorces back when I was 29, 31 years old. I had cases where, both parties had to have both of those ceramic elephants that he brought back from Vietnam, that sort of thing. While I have some background in that, a lot of time has passed and a lot of things have changed, and a lot of things about the tax implications of divorces and so forth have evolved. So one thing I hope to do if I'm elected is to spend a lot of quality time with people who are specialists in that area, boning up on that area of law before I'm actually called upon to be a judge and go to the Family Law Institute and other things to catch up on 30 years of developments in that area. Probate is another one where, I touched on it, but usually when I have those issues, I just associate a probate specialist to do it. So I want to bone up on that in much the same way. And yes, part of collegiality of 15 members is to pick each other's brains. And I would certainly do that.
Well, you're in good company with respect to divorce and trust, wills and trust, because the members of the Court of Appeals have only been dealing with those issues for about a year now due to a big change in the law. Do either of you have comments on that Reform Act? Is it a good thing? Is it going to make your job better? Is it going to make your job harder for the Court of Appeals?
Yes.
Both.
Both.
Okay.
Both.
You think it was well written?
Well, since you have a hand in writing, I think it was superbly written.
I'm teasing. All right, let's talk about your appellate experience. The folks here are going to want to know, the people around the state are going to want to know, you can talk a good game, but have you really, handled appeals? Because those are different. And so I just want to start with, I guess, you, and I need to know, the people need to know, how many times in the last last 10 years roughly that you've served as lead counsel in any appellate court and presented oral argument?
I haven't counted it up. I had a lot more appeals early in my career because there's more stuff going on appeal. In my current practice, there's no appeal from a settlement. A lot of things get resolved on courthouse steps or while the jury's out or after the jury's in. So not that many go on appeal. I have had some cases that made their way through the Georgia appellate courts and the petitions for certiorari to the U.S. Supreme Court. And occasionally you get to oral argument cases. Sometimes the judges just don't grant oral argument if you ask them.
And those are all civil cases?
Those are civil cases.
Okay.
Now, early in my career, there were a lot of criminal cases.
And same for you. What is your experience handling as lead counsel appellate work over the last 10 or 12 years?
Before that, it was more frequent when I was district attorney because almost every conviction gets appealed. And I've argued in the Georgia Supreme Court and the Georgia Court of Appeals personally as lead counsel. I have argued in the Court of Appeals on civil cases as well, and I've certainly written briefs, but as was the other comment a minute ago, and I agree, and it would be something that I think needs to change. The court has gone to granting oral argument less and less, and I think that's inappropriate. In fact, I had oral argument granted in a case last year, and we were 5 days away, and they ungranted it. And I've never heard of such a thing, and I asked someone about it, and they said they'd give me an answer, and they never did. But I think when there's an important issue and oral argument is requested, both sides request it, that it should be granted. And I have not given an oral argument as lead counsel in the last 10 years just because it hasn't been granted, but I've been part of briefs that have gone up and at both courts.
Let me ask you both about a curious rule in the Court of Appeals regarding oral argument. Well, I find it somewhat curious, to be honest with you. I have to, and I know this is being recorded, but I have to file my motion for oral argument before the court even has my briefs in front of it. Is that something, is that a good rule? Is there anything you can do as a member of the court to encourage the chief judge to consider changing that rule? Or maybe you like the rule. I'll start with you.
Well, certainly rules can be amended and changed, and I don't think that a decision should be made until the court is fully cognizant of all the facts and issues, because how can you rule on it until you know? And as you just alluded to, this is being recorded, although I saw another appellate judge tell the story. I'm not going to tell the name like that judge did, but there is a Court of Appeals judge who will never grant oral argument. You know who I'm talking about. Doesn't matter who it is. And that's not appropriate either, just because they don't want to attend oral argument, because these issues are important. They're important to the clients, and they very much affect their rights. They can affect their property rights or their liberty. So I believe in those. Yes, I believe we need to have a review of when oral arguments are granted and how they're granted. And it's also only granted currently by the judge who the case is assigned to. It's the practice of the other two on the panel not to grant it unless the author gives permission. And if it's the three of us, and if you're the presiding and you just don't want to have it, and Mr. Shigley and I think it's important, or just one of the two of us thinks it's important, I think we ought to have oral argument.
I think we agree on that. I think it touches on something that I brought up earlier, that when you have a panel of 3 judges and only one of those is assigned to write a decision, and sometimes that judge doesn't look at it until a staff attorney, law clerk, has written a proposed order, it's a very slippery slope between that and the one law clerk decision. If you have oral argument, and if anybody on the panel can say, yeah, I think we ought to hear our oral argument on that case, then it helps to focus the judge's attention and not just pass it off to staff, which can happen. We need to avoid it.
I'm going to ask you to identify a challenge that's facing the Georgia Court of Appeals and how you think that they could, if you've got any ideas for improving it.
Well, I think one challenge is simply the volume of case law. That has always been a problem with the Georgia Court of Appeals. And then you add 3 judges and then expand the jurisdiction. So you got still probably the busiest caseload per judge of any intermediate appellate court in the country, even after adding 3 judges, because now you've added divorce cases and other things that used to go straight to the Supreme Court. I think that caseload is a huge challenge. Some of the things that have been done recently in terms of utilizing technology may help to streamline things to some extent, in that you're not dealing with masses of paper, you're dealing with masses of PDF documents that you can read from anywhere, and help to implement, help to facilitate doing the research and so forth. One thing that I personally would do is to is every one of those decisions, every case and every authority that is cited, immediately pull them up and read them before a staff attorney writes anything. I wouldn't be the bottleneck, but after assigning something to the staff attorney to work on, I would read it and give the staff attorney guidance as to what my thinking is, and things we need to look at carefully. The technology can help in that. But there's no substitute for just doing the hard work.
Well, we've hit on a number of issues already, from inconsistent opinions to one-judge decisions to oral arguments not being granted in there. And so there are a lot of things that need work. And as one of the 15, I'm going to exercise the influence that I'll have with my colleagues to make changes in all of those areas. It's hard to pick the most important, and it's hard to pick. And I guess you also, you eat the elephant one bite at a time, so you got to, start and keep going to get all the way through it. But I would start probably with those that are the easiest to solve, if we can get those done. Like granting moral argument, changing the rule of when we accept request for oral argument, that's probably the easiest. And then moving to probably some that have the most profound effect on everyone and their rights, and that is the inconsistent opinions and the one-judge decisions.
Appreciate that. Okay, so now I'm going to ask a specific question to each of you, so I'm going to go back to you. I represent a lot of companies, a lot of corporations. I defend them in litigation. I do some of a friend of the court briefing for the Chamber of Commerce. You're a well-established, well-known plaintiff's lawyer. My clients ask me, should I be concerned about Mr. Shigley on the bench? Tell me why they shouldn't be concerned.
Well, I'll tell you the same thing I said at the Chamber of Commerce interview last summer when Ray Ford, who's the General Counsel of SunTrust, asked much the same question. I said, Ray, I've known Ray through Boy Scouts for years and years, SunTrust Scouts together. I said, Ray, I would react to cases where there's not a good basis of liability the same way I do now, and tell people every week, almost every week, I'm sorry you got this problem, but you don't have a case.
Okay, fair enough.
One thing the court must be very careful not to do is to not kill the goose the way to kill the egg. We have a state that is very business friendly. It's one of the best states in the country to do business, and you don't want to destroy it.
And my question for you is, if elected, are you going to be able to serve as state bar president, given the lobbying role of the state bar, and should that concern the voters that you may not be able to serve as a state bar president? I don't know the answer to that question. I just keep hearing this.
No, that's a good question. I doubt it concerns anybody in this room because they're not lawyers, and I doubt they could care less who the state bar president is. But I am president-elect of the state bar, if elected to the court, I will be the very first appellate court judge to serve as state bar president at the same time. The answer to your question is, I believe that I can fulfill both roles. And I say that having given it serious thought and in consultation with both Court of Appeals judges and Supreme Court justices. In fact, this very weekend, the executive committee on which I serve will be going to a meeting with the Supreme Court and meeting one-on-one with the 9 Supreme Court justices. And I had a very candid conversation with Justice Blackwell, who is the liaison for the Supreme Court to very issue. First of all, I will have served 7 months as bar president before I'm sworn into office. And so the bulk of what I do will be out of the way. The specific question you asked about lobbying, I will tell you that there is, you can read the judicial canons of ethics, as I'm sure you have, and I have as well, and there's nothing that prohibits judges from going down to the legislature and advocating for things that promote the judiciary. And that is the only lobbying that I would do anyway. And I would suggest to you that many justices, including David Namias, when we were talking about the JQC issue recently, go down and do that very thing. But I would do it within the confines of the judicial canons of ethics. And getting back to the question before, would I be able to go to my colleagues and ask for input from them? Would I be able to have that kind of humility? I've already told them, and I would tell them, if you see that there's a conflict and you see that I can't do the job, let me know and I'll step down, and Darrell Sutton will be happy to fill my place.
Let's be honest here. I'm thinking back to Justice Namias' runoff with Tammy Lynn Atkins. Realistically, what percentage of the voting public that shows up on May 22nd is going to have any knowledge of anything that distinguishes you from your opponent? Is that a problem? And should we elect appellate judges in Georgia?
Well, I think we all know that a very small percentage of the electorate knows anything about judicial candidates. Can you hear me in the back? Okay. I think we all know that a very small percentage of the electorate knows anything about most judicial candidates, unless it was somebody in their own county who got in a scandal and embarrassed themselves. Somebody asked me recently, out in Paulding County, well, how do you compare judicial appointments and judicial elections? How do those, which is better, which is worse? Both are bad, depending on how you run it. If it's about appointment, hopefully you've got some good screening of qualifications and experience. If not, then that can be bad. Now, the election process usually goes in an open election to whoever's first in the alphabet. The last 3 open elections for this court have had 6 or 7 candidates, and the first person in alphabetical order, regardless of qualifications, has a huge advantage. And that's worrisome to a guy whose name is Shigley. It starts with an S. Yeah, right. And it's amazing to me that we wound up in an open election here with only 2 candidates. So a guy with a funny name at the bottom of the alphabet that rhymes with Piggly Wiggly can actually have a shot. That's amazing to me. These elections are tough, but it does give an opportunity for the people of the state to have a voice in selecting who's going to be on the court, and hopefully they'll be good ones.
Same question. Just any thoughts about how the process works and the fact that the Court of Appeals is a statewide race and it's so hard to get the public's knowledge as they walk in of either one?
Well, it is hard to get the public engaged, but we don't have that problem with about 75 people here in Cherokee County, and I'm thankful for that. And you should applaud yourselves, and thank you for being here. And I don't want you to vote for me because I'm first on the ballot. I want you to vote for me because you like what I've got to say. And I'm happy to talk to you one-on-one after this so you can learn more about me. But the things that I told you, I'm a 15-year prosecutor. I've been out there in the trenches standing up for victims in rural Georgia. And for those of you who do take stock, I don't discount the people whose reputations I think a lot of, who are standing with me, like Johnny Isaacs and Saxby Chambliss, Bob Barr, and Jack Kingston. And if it takes me using their coattails, if you will, to get my message out, that's what I'm going to do. But I'm going to be sending out mailers everywhere in the state. I'm going to be trying to get phone calls out everywhere in the state. I'm going to try to educate people. And I want them to be educated on this. And I want them to vote for who they want to protect their interests. Because when your case goes to court, and I hope it never does, but if it does, you're going to have your property rights at issue, and you're going to have your liberty at issue, depending on the case that's going forward. And you're going to want somebody there who has advocated for someone who's in your shoes. And that's who I will be. And so we live in the best country on earth. We I want you to make the right decision for you, and I am very happy to stand for election for the Board of Appeals.
We're actually going to take closing statements now.
Okay?
So you can, that almost sounded like a...
It did.
So
I think that was-
you may just
Go ahead.
you may want to defer and just close on that, but go ahead,
Okay.
and then you can go for 3 minutes.
People ask me, what would possess you to want to leave a successful law practice, to take a pay cut to serve on the Court of Appeals, and spend your time reading turgid lawyer briefs? Well, this is a career goal that I've had for a very long time. When my wife and I saw that there was going to be an opportunity to go for an open seat on the Court of Appeals, we decided it was something we wanted to do. And last March, Brother Hodges came up to me and told me he was going to run too, and I drove home thinking, oh my gosh, I've got a real politician in the race with me. What do I do? He had just come off running for Attorney General on the Democratic ticket in 2010 and had a lot more political background than that. But I decided it was something I was going to try anyway. And then about 3 weeks later, my wife's oncologist told her they'd run out of options and referred her to hospice. And I thought, this is a great excuse for me not to run. And we got home and she said, she gave me a honeydew list. And item number 5 on that honeydew list was don't quit that judge race. So we'll see. And about a month after she passed in June, I said, okay, I'll go ahead and do it. Now, I do not have the political background and political skills to line up endorsements from career politicians, or to make as many and as effective fundraising calls. So I wrote a check for $250,000 for my own campaign in order to be competitive. Now, I would appreciate your vote to allow me to go down to the Court of Appeals and do what I've done for 40 years, which is to try to be fair to people and to apply the law as it was written and intended in the cases that come before me on the court for the balance of my career. I have no further aspirations. This is the only thing I'm ever going to run for. I'm not going to use it as a springboard to run for senator or governor or anything else. Thank you.
Ken, your final closing statement?
I need your vote. May 22nd is 43 days away. And if you like what you heard, I hope you'll share that information on social media via Facebook or however you want to share that. Word of mouth is still very important. And again, I thank you for coming out and getting educated. My website is easy. It's kenhodges.com. You will be voting for somebody that will be proud to continue his career of public service. I know, Mr. Stack, I shouldn't digress and answer questions, but, you know, he just said that he's not a career politician and he doesn't know how to, he doesn't have the skills to know how to ask for all these endorsements. Ladies and gentlemen, simple. Do you think Saxby Chambliss, Bob Barr, Jack Kingston, and Johnny Isaacson just gave me their reputations because I've run for public office before? Absolutely not. They did because they know me, they trust me, they know that I share the same values. So the only skill I developed was asking for their support. He's asked for the support of the Cobb County Sheriff, and he's gotten one, so he knows how to do it. He's being disingenuous, and you don't need to want a disingenuous judge. I want your support. I will be honest with you, and I'm happy to address, if you think it's important, why I ran as a Democrat before. Very quickly, I'll tell you, I grew up in a county that has never, ever elected a Republican. My father was the head of the Republican Party in the county where I grew up in. We discussed whether I should run as a Democrat or a Republican for the office of district attorney, which is an office which really should be nonpartisan to begin with. And I'm happy to have that discussion with anyone. But you want a judge who is going to be fair, impartial, who is going to stand up for you and your rights and has the background to do it. And I have that. And if you want to talk one-on-one about it, I'd love to. Or if you want to look to the people that are supporting me, I've got a wide range of people who know me and know me well and will tell you that I'm the right person to be a judge.
Hold your applause for just a second. Let me say something real quick. I want to thank both of you for coming. I know that this is outside of your county. I know you've been here before. We really appreciate you coming for a statewide race. I want to say that the people of Georgia are in good hands, having two very well qualified candidates running. This is not a race where one of the two candidates has no business running for the Court of Appeals. We've seen that many, many times. I'll just tell you folks. And we've even had runoffs between Justice Namias and again, Tammy Lynn Atkins, who I don't think had ever been to the Court of Appeals in her life. We're thankful for you. Best of luck for the rest of your race, and thanks for being here.